here might indicate. I am not going to ask the panel of 64 the question presented. There was, each party was provided ample opportunity and time to ask questions, and the record is replete with answers from all of the jurors to those questions. I'm not intending to reopen jury selection, which is effectively what that question would ask the court to do. As to the motion in limine, I do believe it's premature. I understand Mr. Goff's concern about it, but it almost feels like hearing the state and Mr. Goff talk about what this conspiracy after the fact is. It's almost like apples and oranges a little bit. That I'm not getting a real connection on specifically where we're going with it. Generally, I will look at the evidence at the end of the case to determine whether a charge is appropriate. If that charge is appropriate at the end of the case, we'll go ahead and address that. I do understand and respect the defendant's concern about where Mr. Bryan may fall within that legal theory, but without hearing the evidence or understanding exactly what the state's theory of the case is going to be, at this point I think it would be premature for the court to make a ruling on that motion. But I do understand that that right is being reserved to go ahead and raise the issue again. I understand where we are, but at this point I think we're premature.
The only thing I would add, and I'll be brief, is once we started the trial, we're stuck isn't the word for it. We have the jurors we have. That may limit the court's remedial options at that time. I'm just given the complexity of jury selection in this case, I just thought I would point that one thing out. I have nothing else to say.
As trial goes on, we all get painted into corners, so that's where we are. I understand. As to the motion to sever, I understand the defendant's position right now. We're putting that on the record. And as far as time to confer, I'm still trying to work through the panel. There's time now to start talking about it, and I'm trying to figure out where we are numbers-wise. I would like to see counsel in chambers about that so that you all can just get an update on where the court is numbers-wise. Anything then beyond that I'll just start on my left, from the state.
Just an inquiry as to whether the court would reconsider the state's motion to excuse for cause juror 466. Having pulled juror 466, my notes from last night, once again, his wife works with Lee McMichael in the exact same department with her. Wife is in medical records. Lee is not her supervisor. However, it would put my wife in a weird situation, possibly if the jury came back guilty, put her in an impossible situation at work, probably a better chance that he will not be fair and impartial due to his wife. Wife can supersede objectivity. It would be on my subconscious, and that is why we're actually motioning at this point in time to excuse him for cause. And it is the state's failure for having not motioned at the time. I understand that, but we wanted the court to see if the court would reconsider this.
The court's position generally on any reconsideration is if there is no new information, nothing available to the court that would require reconsideration, then the court will not move on that. So as far as I'm concerned, again, the parties had ample opportunities to examine the potential jurors, and also then had an opportunity to consider the motions that were being made as well as the court's ruling. The court ruled. Remains the ruling of the court.
Thank you, Judge.
Anything from Travis McMichael?
No, Your Honor, listening.
From Greg McMichael?
Just one moment, Your Honor. We may have one short motion to make in just a moment, based on something the court just said about reconsidering a juror for whom extrajudicial information has been acquired after the voir dire examination.
I don't think that's not what I just addressed. What I just addressed was information that was known to the parties at the time the court made the ruling.
Right. And that made me infer that if the information was not known to the parties at the time of the examination and has since been acquired, then a motion that was not made when we did not know the information could then be made, as was just done by the state, but based on information we already all knew. We may have one juror, potential juror, about whom we have acquired extrajudicial information not acquired during the examination of that juror. If Mr. Rubin is prepared to go forward on that, you have that?
I do. And Your Honor, I was going to raise that issue. It was suggested to me. I'm just trying to be a team player here, but I'm sure I know which juror this is, and we're going to be joining in that.
If the court will indulge me.
Not sure what I'm indulging you in, so go ahead.
Your Honor, we would move to strike for cause juror number 140 based on information we learned after he was voir dired a week or so ago. Juror 140, in response to questioning, admitted to having an arrest out of the Bronx, New York, for a misdemeanor, I think is how he put it. My notes don't reflect he disclosed anything else, and I admit my notes are not as good as Ms. Hoag's, and may not be as good as the state's, but he admitted an arrest for fighting in New York, and he had no opinion on how he was treated, I think was the follow-up question. Our information based on investigation is that, in fact, Juror 140 had multiple arrests and convictions, all for misdemeanors, that we can tell based on New York law, stemming from as far back as the 90s, mid-90s, 2002, 2004, 97, multiple arrests for what looks to be either a stalking or harassment type offenses, and with protective orders as part of the sentence. Some periods of imprisonment, 5 days or a couple months. Again, nothing that rises to the level of felonies, but the lack of candor from the juror, it was concerning to us enough that we followed through with getting the New York records. And given the additional information, given his lack of candor, we would move to strike. And I can show this date. I don't have it printed out, but I can certainly show this date. They may know this already. But we would move to strike juror number 140 for cause based on this new information.
I understand that Mr. Bryan's joining the motion from the state.
Judge, I have no information. This is the first the state is hearing of this morning. I am going to ask my investigator to look into this, but it appears the representation is it's a series of misdemeanors. So there is no felony conviction here. And it appears that this juror was born in 1977, and the dates appear to be around those times. The problem, Your Honor, is, as you know, with any criminal history, often the arrest shows up, the disposition shows up, and something else shows up, and it looks like there's 3 separate incidents on 3 separate dates when it's all one incident. So I would like the opportunity, of course, to look at this. But basically, based on the fact that there is less candor with the court, that's not a reason to go ahead and now strike this juror for cause based on telling us about a misdemeanor he'd had for fighting and then not telling us about a few others, if that's what the case is. And we don't even know if that's the case. So we ask that you deny the motion for cause based on that. Obviously, the defense, just like the state, has the opportunity to use a peremptory strike on juror 140.
Okay.
You know, in my limited experience, which is somewhat dated from the prosecutor's perspective, New York criminal histories can be sketchy, hard to decipher. I thought it was a felony. Coming in this morning, I was told it was a misdemeanor. I would defer to the McMichaels and the state on that, but I think that's something we certainly want to concur on. It would be a shame in Georgia, unlike some states, if you you have a convicted felon on the jury, that's not harmless error.
And I can add to that too. What we also found was a local news article in the Brunswick News reporting that juror 140 was, I don't think he was arrested, but the article referred to a felony conviction. Of course, we're not relying on a newspaper article to establish that, but it was here in Brunswick not that long ago, and it involved the pulling of a gun on a person at an apartment swimming pool by juror 140, and the police were called out, and the newspaper, of course, as we've well established, media doesn't always get the facts right, reported that he had a felony. That's what set us off to search for this. And again, it doesn't appear that there's a felony on the New York record, but that's how the trail got started.
Okay. All right. Let's get the information to the state. Let the state review the information. We're going to be reconvening here in about 15 minutes. What time is it now? It's 10 past? No, quarter past. So let's go, plan on 10:30. If I could see council in the back, just so that we can update everybody on where we are with the panel.
Is that the now or at 10:30? Is that before or after?
That's now.
Okay.
Thank you.